Hi, I'm Burkhardt Beale with the law firm of Boone Beale. We have put together a series of videos that we encourage you to watch to educate you about the defense of your case. We use that same method to educate a judge or a jury in the defense of your case. Let's talk, let's learn together about the defenses, and let's win. I learned in college that the #1 suicide in the jails of America is a DUI arrestee. I know how serious this matter is and how concerned you may be when you're sitting at home the night after you've been arrested and wondering if your life is over or you've reached some endpoint in your life. Perhaps the DUI is only a tip of the iceberg, and there are a lot more troubling issues ongoing in your life. We have several counselors that we can refer you to assist you with this process. First of all, we need to take care of you as an individual, and then we will turn our attention to your legal case. If you are facing a first offense of DUI, it carries with it a minimum fine of $250, a maximum of $2,500. There's no mandatory minimum jail on a normal first offense DUI, but if you have an elevated blood alcohol level of a 0.15 or higher, there's a mandatory minimum 5 days in jail, and if it's a 0.21 or higher blood alcohol, it's a mandatory minimum 10 days in jail. We'll talk about all the other details or consult the website for the actual statutory language. A second offense of DUI or DWI carries with it a minimum fine of $500, a maximum fine of $2,500. There is a minimum jail sentence of 30 days, 20 of which are mandatory if it's within a 5-year period, 10 days of which are mandatory if it's within a 10-year period of your first offense. If you are unfortunate enough to be facing a third offense of DUI or DWI within a 10-year time frame, you are facing a felony that carries with it the potential punishment of 1 to 5 years in the penitentiary. There is a mandatory minimum 6 months in jail if it's a third offense within 5 years, and a mandatory minimum 90 days in jail if it's a third offense within 10 years. If you are facing a fourth offense of DUI or DWI, there is a mandatory minimum jail sentence of 1 year in the penitentiary or 12 months in jail. It's an extremely harsh punishment for a fourth offense that is applicable if it occurred within 10 years of the 3 priors. You may be charged with an additional offense of refusing to take a blood or breath test. If it's a first offense and you are convicted, it causes you to lose your driver's license for a period of 1 year without any possibility of getting a restricted license. On a second offense, it carries with it a 3-year license suspension, plus an additional term of punishment, which could be up to 6 months in jail and up to a $1,000 fine. On a third offense of refusing, you can be convicted and lose your license for a period of 3 years, plus an additional jail sentence up to 12 months and a fine of up to $2,500. We need to talk with you about the defenses to this additional charge. One of the things that you're concerned about is what happens to my driver's license when I'm convicted of a DUI. On a first offense, there's a mandatory loss of your license for a period of 1 year. On a second offense within 10 years, there is a 3-year license suspension. If it is a third offense within 10 years, it is a lifetime suspension of your license. Depending on whether or not it's a first or second offense, there will be a period of time that you may be without a license altogether. But normally on a first offense, you will be able to get a restricted permit if you are convicted. Right now, as you're sitting there looking at this video or looking at our website, you may be thinking to yourself, why in the world should I contact an attorney? I tested over the legal limit. I drank, I drove, and maybe I should just accept the fact that I'll be found guilty. Well, let me tell you, that would be a serious mistake. You should pick up the phone and call and talk with us about the circumstances of your case, because you do not know whether or not it's a case that can be won or lost at this time. Don't prejudge your case, and don't feel, because you have tested over the legal limit, that your case is already lost. Nothing could be further from the truth. I have won the majority of my cases, even though the person charged tested above the legal limit. So give us a call and we can talk about all of the particular details in your case to determine whether or not you have a chance of success. As you're sitting at home wondering about whether or not there is a defense, please know that there are a number of possible defenses to a DUI or DWI. One possible defense is a rising blood alcohol content or rising blood alcohol level. A second one is the Tyndall effect that may apply if your airbag's deployed and you were in an accident. A third defense may be a raised body temperature causing a breath test to read falsely high. There may be interference in your breath or other defenses. The facts of your particular case will determine what is the best possible defense. Let's talk. One defense that I mentioned was a rising blood alcohol level. This may occur as a result of your having a drink shortly before leaving a bar, or perhaps you ate a meal and the drinks haven't yet gotten into your system. What the law is interested in is your blood alcohol level at the time you're driving. We will look at that very closely in our interview to determine whether or not this defense applies in your case. Oftentimes, when you're pulled over by a police officer, you become very nervous. This may cause you to have stomach problems or gastric reflux or acid reflux as a result. Perhaps it's a condition you already suffer from in your own medication. Unfortunately, if you have acid reflux or you're burping or belching because of the nervousness of your stomach, this may cause the breath test to be much higher than your actual blood alcohol level. We can talk about this as one of the defenses to a DUI. One possible defense in your case may apply if your airbag's deployed. It's called a Tyndall effect type of defense. When your airbags are packed inside of your steering column, they are packed with talc powder, and when they disperse or explode, there is a large smoke field that occurs. you will breathe in that talc powder into your lungs, and when you blow in to a breath testing device, that talc powder will actually leave your lungs and create what is known as the Tyndall effect. The absorption of light in the infrared testing device will cause a false high reading. We need to talk about this in detail when you consult with us. Your situation did not occur in a vacuum. Perhaps you are suffering from a fever, or you have allergy problems and you're taking an antihistamine. If you're taking a medication, or you're just suffering from a fever and your body core temperature is higher, that will affect a breath test. For every 1 degree rise in your body temperature on a centigrade scale, it will cause a corresponding 10% higher reading on a breath test. Many people want to know whether or not what the police officer did was illegal in their case. Should they have done it? Should they not have done it? Well, the point is they did it. It may lead to a defense, and if so, we will use that on your behalf. Most likely, it will show us a method that we can get under the police officer's skin in cross-examination to bring forth a win in your case. There are 3 aspects of your case when it goes to trial. First of all, whether or not there is reasonable, articulable suspicion to stop. Secondly, whether or not there was probable cause to arrest. And lastly, whether or not there is proof beyond a reasonable doubt. Whether or not there is reasonable, articulable suspicion will be governed by your actual driving behavior. It will be before the police officer puts on his lights and siren to pull you over. Whether or not there is probable cause to arrest you will be determined by the interaction between you and the police officer after he has pulled you over. The field sobriety tests that you performed, how you conducted yourself, how you handled the questions by the police officer. These will all go to probable cause. We could win your case at the hearing based on the lack of a reasonable, articulable suspicion to stop, or at the level of probable cause to arrest. If not, then the case will proceed to determine whether or not there is proof beyond a reasonable doubt. That is when we will be putting on evidence on your behalf in your case. One field sobriety test that may have been given to you is the one-legged stand. If you're over 65 or more than 50 pounds overweight, this test should not have been given to you as part of any testing protocol. What the police officer is looking for is whether or not you put the foot that you've raised in the air down before you get to the count of 30. The second thing is whether or not you hop on your other foot to keep from putting your foot down. The third thing that he is supposed to be looking for is whether or not you raise your arms from your side. The fourth and final thing that he's looking for is whether or not you are swaying. We will cross-examine the police officer very precisely as to how he conducted the test, because sometimes the errors are made by the way the officer gives it rather than the way you performed the test. One field sobriety test you may have been given is called the walk and turn test, where the officer asks you to walk 9 paces, heel to toe, turn around on a pivot, and walk back 9 paces. The officer is looking for 9 different clues or cues when you are performing this particular test, and we will cross-examine him closely on these issues. He can cause you to have difficulty on this test by standing too near you, walking alongside of you as you're doing the test, or by putting you on a surface or terrain that is unlevel or uneven. Lastly, if you're a woman, there is no way that you can conduct this test the same way that a man can because of your hip structure. This particular test should not be allowed when conducting an inquiry on a female. One field sobriety test that the officer may have had you perform is touching your finger to your nose. You extend your arm out and touch the tip of your nose with your finger. They will critique you on he touched the bridge of his nose or the upper lip or things of this nature. But one thing I want to drive home to you is that NHTSA has determined that there is no statistical correlation between the finger-to-nose touch and whether or not your blood alcohol level is above a 0.10. This is an important piece to the puzzle which we must present to the judge or jury in making a decision in your case. One of the field tests you were probably asked to perform was the horizontal gaze nystagmus test. Nystagmus refers to the rapid movement of your eyeball, such as I'm demonstrating with my hand right now. It's where your eyeball is bouncing while following a stimulus that is used by the police officer, passing it in front of your field of vision. The officer could have induced nystagmus in your eye by either moving the stimulus too quickly, moving it too close to your eyes, or not allowing for enough time for you to follow the pen while conducting the test. In addition to a DUI, you may have been charged with an unreasonable refusal to allow the taking of a blood or breath test. You may have been charged with a refusal even though you blew into the device, blew repeatedly into the device, and kept getting error code messages on the breath testing device. Is that fair? Is that legal? Or is that a defense? You need to talk to us in detail about that, because often we can show that it was not you that was wrong, but it was the officer who made a mistake, and have you found not guilty of refusing to take this test. Before we begin a trial in any case, we always want to know what we want to be saying at the end of the case. That's called the theme of your case. The theme of your case may be acid reflux as the defense. It may be that it's the Tyndall effect that is the theory of our defense. It may be rising blood alcohol. All of these may apply, but when we present the case to the court, to a judge or jury, we need to pick what is the central theme of your case and present that and drive it home so that you can be found not guilty. One question you may have is whether or not I need an attorney. People call me about all types of matters, and I do not recommend an attorney where it's a non-serious matter that doesn't have severe consequences. But I would caution you on a DUI that you always need an attorney that knows how to handle your case. You would not consider performing surgery upon yourself, and the same thing is true with a DUI. You need an experienced individual who has an objective perspective leading you through this matter. You should definitely talk to an attorney to determine what the defenses are in your case and whether or not you make a decision to hire one will then at least be an informed decision. Why are the attorneys different here at Boone Beale? First of all, it's because we care. We care about you, the individual. We understand how stressful this time is for you. Many people come in to our office with the stress still showing in their face and in their actions. We will take care of you. You need to know once you hire our firm, and if we agree to take on your case, that you can sit back and relax and let us do the work and take on the stress, which you can leave behind at our office. We take a team approach to the defense of your case, which means that you will be talking with our paralegals, investigators, our toxicologists that we use, as well as the attorney assigned to your case. You are an essential member of the team. You are the one that's in possession of the facts and may prove to be the critical witness in the defense of your case. You will always be treated as a team member, which means that we will keep you informed about your case at every step of the process. Essentially, you need to know everything we know about the defense of your case. One thing that is important in the defense of your DUI is the reputation of your attorney. We enjoy a very good reputation based upon our sound ethics and the fact that we have been speaking at continuing legal education seminars on the defense of DUIs for a number of years. I have spoken for more than 20 years, more than 100 times, training other lawyers how to defend cases, both here in the Commonwealth of Virginia and nationally. Be sure you speak with someone that knows what they're talking about before you make your decision. What are the credentials of an attorney at Boone Beale? First of all, our law firm is preeminently rated by Martindale-Hubbell. That is a peer review by other lawyers, judges, prosecutors about the quality of your firm. Only 3% of the nation's attorneys deserve this high ranking in Martindale-Hubbell. We are also trained in field sobriety testing, breath testing, as well as having former police officers and prosecutors in our law firm that will assist you in defending your case. Many people ask, why are you so successful in DUI defense? One of the reasons is we take a unique approach to every case that comes into our office. I cannot tell you how many times a judge has looked down at me from the bench after the trial of a case and a dismissal, telling me they had never heard that issue raised before by any other attorney that appeared in his court. It is this detailed approach that we take that wins cases. Sometimes people wonder, how do we win cases? A lot of times it's based on cross-examination of the police officer. I have found through my experience that about 65 to 70% of the time the police officer conducts the field sobriety test incorrectly, and I can focus the attention of either the judge or the jury on the fact that the police officer was messing up rather than letting them focus on how you performed on the test. Another way that I have found that we can win cases is on technical issues. The highest BAC case I ever won was a .34. My client was so intoxicated she couldn't even get out of her vehicle to stand up to take field sobriety tests. but on a technical basis, I was able to keep the blood alcohol level of 0.34 out of evidence in the case, and she was found not guilty. Do not prejudge your case. Talk to us, and we can fashion a defense if one exists. If it's there, we will find it. One question that has to be at the back of your mind is, do I get a guarantee, or can I get a guarantee from you as my attorney? Unfortunately not. It is unethical for an attorney to guarantee a result in your case. We can talk about your case and compare it to prior offenses. Much like the stock market, we can predict what the probability of success is in your case based upon what we have seen in the past. But just like when you're buying a stock, past performance does not always guarantee continued success. We need to talk in detail when you meet with us. There are many different aspects to the handling of a case. First of all, it's having strong interpersonal relationships with the court personnel and the prosecutors that you handle cases with on a regular basis. We do not go in with our sleeves rolled up, ready for a fight when we go in to negotiate your case, because that method will only cause a prosecutor to dig in their heels to fight you back. If we are not successful in negotiating a case, then we do roll up our sleeves to go into the courtroom. You want to pick an attorney that has the fire in his gut to handle your case and fight your case successfully. I can assure you at Boone Beale, we have that. You may be wondering how the law firm of Boone Beale determines the fees that they will charge in your particular case. Well, let me explain first of all that there is no standard or set fee that applies across the board to every DUI. It's kind of like going out and buying a home. Each property is unique and has unique characteristics. Your case will have its own unique circumstances or unique characteristics that will determine what the fees will be charged in your case. Just like you cannot make a final decision about the purchase of an expensive piece of property, you can't make a realistic determination of who you would like to have represent you until you sit down and discuss all of the details. One of the things that you may be wondering about is how a fee can be set with an attorney on a criminal matter. We are not allowed to charge contingent fees like occur in a personal injury case. So there has to be a set fee established between the attorney and client when we take on a criminal representation. We charge a flat fee, which will be discussed in detail with you before you hire us. The only thing that there may be in addition are costs incurred, which are specific to your case, such as getting the information from forensic sciences about the breath device that was used in your case. Possibly we may need to use an expert, and his fees are not included in ours. We will discuss all of this in detail and not incur any cost in your case unless you have given us permission or authorized that expense. Oftentimes, people want to know whether or not I am the right attorney for them. I tell them that you need to answer yes to 3 simple questions before you can answer that question for yourself. First of all, do you trust me? Can you tell me the deepest and darkest secrets of your case? Secondly, when I talk to you, do you understand what I have to say? Do I communicate well with you? Thirdly, do I understand what I'm talking about? Do I know what I'm talking about? If you can answer yes to these 3 simple questions, you know that I can be the right attorney for you. What can you expect at the initial interview? One thing you can expect is it will be a lengthy process because we need to listen and gather all the details in your case. You may have talked to someone else that spent maybe 5 to 10 minutes with you talking about either how good they are or what their track record is. But what we want to do is spend the time listening to you and all the facts and details of your case. It is with only these detailed interviews and the detailed information that we can fashion a defense to your case. How do you prepare for an initial interview? The easiest thing may be to fill out our questionnaire, which has all the details that we are looking for. If you work better free form, then just write down all the details. Give us all the facts and circumstances of the day's events that occurred within 24 hours before you were arrested for this DUI. We need to know what you had to eat, what you had to drink, and all of the persons that you spoke with on that day. Perhaps you may forget the name of a witness or other detailed information if you ignore doing this within the first 24 to 48 hours after your arrest. These details are what provide a winning combination for your case. Your first court appearance in most courts is either an arraignment or an initial appearance in federal court. At the arraignment procedure, the court is going to describe to you how you go about getting a court-appointed attorney if you qualify for one. Additionally, they'll explain to you that you're charged with an offense that carries with it the possibility of a jail sentence, and because of that, you're entitled to be represented by an attorney. Generally, nothing major is accomplished at this hearing, but your new court date will be scheduled. Many courts will waive this initial arraignment or initial appearance if you already have an attorney on board, because the reason for having the hearing will no longer be needed. How are pleas negotiated between attorneys? Well, first of all, the judge is not involved in this plea negotiation process. The plea agreements that are reached take place between your attorney and the prosecutor who is assigned to the case. The negotiations usually take place at the day of court rather than well in advance of your court date. Certainly, it would be easier on you to have this done or accomplished before your day in court. But the reality of it is that the prosecutor has not had an opportunity to speak with the arresting officer until the day of court and will not be in a position to make that final decision till that day. Certainly you're going to want to know what your day in court will be like. You're going to be nervous, but the way you need to avoid the nervousness is by preparation. That's by consulting with us back and forth between the time you have first contacted us and until the time of your case. We will be in constant communication with you, providing you with all of the information concerning your case so that you will be ready for your day in court. I have a few final comments that I want to make to you as you're departing from our website. First of all, our firm is comprised of many, many lawyers, and we have a combined experience of over 100 years that will be on your side. I personally have practiced law for 26 years and handled more than 4,000 cases. The majority of those I've won. Rest assured, if we take on the responsibility of your case, we will earn your trust.
That was good.